The first stage of a mediation is the stage at which we say that the mediator sets the table. That means that he firstly will endeavor to relax the parties by getting them to refer to one another on first name terms, if possible and where possible, and then will explain to them the procedure that will be followed during the course of the mediation. Mediation is a voluntary process, and of course the parties embark upon mediation by agreement. And so there is, in all instances, a written agreement that sets the terms of the relationship between the parties. And this written agreement is dealt with at some length in the opening session, in which the mediator explains to the parties what the essential ingredients of the mediation are. Mediation, what the mediator does in a mediation, a facilitative mediation, is he doesn't take a decision on behalf of the parties, but he merely sets the stage and creates an environment for the parties themselves to arrive at a solution to their dispute that both of them, or all of them in the case of multi-party disputes, find acceptable. He doesn't prescribe the outcome to the parties at all. And everything that is done during the course of a mediation is designed to create an environment conducive to assist the parties in order to find common ground, so that the mediator is in control of the process. The mediator does not determine the outcome. The outcome is determined by the parties themselves, and the mediator regulates the process. In the opening address, the mediator will explain to the parties how precisely he is going to regulate that process. An important aspect of this is to ensure that the parties do not interrupt one another, that they do not become violent, that they do not become abusive. And the manner in which the mediator achieves that is to ensure that both parties agree to what he would call perhaps ground rules, and that is that the parties will not interrupt one another, that they will not raise their voices, roll their eyes, and behave in an unseemly manner at any stage during the course of the mediation. Mediation is also voluntary, and during the opening session, the mediator will lay emphasis on the fact that the parties have come to the mediation of their own accord, and that they're accordingly free to leave whenever they want to. But he will get their buy-in and an undertaking from both of them that they will not leave before giving him an opportunity to address them. All of these things are explained in the opening address, as are the most important aspects of a mediation, and that is the issue of confidentiality and the fact that the proceedings take place without prejudice to any of the parties' rights. Why this is done is so that the mediator, in the course of interacting with the parties, both whilst they're together and in separate side meetings, can delve as deep as the parties will allow him to go in order to ascertain what the real interests of the parties are. And this is the huge difference between litigation and mediation. In litigation, a judge decides who he believes is right and who he believes is wrong, and believe you me, that is not a precise science, and different judges come to different conclusions as to who is right and who is wrong, because what happens is the judge measures facts according to the law and then bases a decision on what his findings of fact are and his understanding of the law. In mediation, the situation is completely different. In mediation, the mediator is not trying to see who is right and who is wrong. What the mediator does in mediation is he determines what the parties' underlying interests are. What is it that caused the dispute between the parties, and what is it that the parties to the dispute would like to avoid? What are their true interests? And one frequently finds that when you investigate interests as opposed to rights, that there is a massive difference between what somebody really wants out of a dispute situation and who is right and who is wrong. In mediation, we seek to find a solution that is a win-win solution, in the sense that it's a solution that suits both parties best. And difficult for people in conflict to believe that this can be done. But a skilled mediator who investigates interests, real interests and real concerns, as the mediation role play shows, is in a position ultimately to fix real interests and to guide the parties to find their own solution based on what their real interests are. So everything you see in the opening phase is designed to set the stage, as it were, for the parties' interests to be explored.